thought you wanted to say something, Mr. Mnisi.
Yes, requesting an indulgence just to address the court on one aspect.
You want to?
I'm requesting for an indulgence just to address the court on one aspect relating to this witness.
Okay.
Yes. My Lord, it will be remembered that at the onset of at the inception of this trial within a trial, the state made mention of the fact that there are statements that the state would want to prove in respect of accused number 3, 4, and 5. There was a bit of a request for clarification there as to what is it that the state would want to demonstrate to the court on the content of the said statement that the state says it wants to prove against accused number 3, 4, 5. Then the state said it is just the statement, my lord. Now, on the documents that we have been furnished by the state, which are the statement regarding the interview with the suspect, which is the document that the state intends to prove against accused number 3, 4, and 5, we have noted, my lord, that there's a portion where this witness also participated in that document. To be very specific, he participated as a commissioner of oath. Now, before the court could resume, we took this aspect up with our colleague for the State Advocate Baloyi and wanted to clarify with him as to whether or not would then that be the beginning of a testimony on the aspect of admissibility of the document that we mentioned at the beginning of the trial within the trial as they relate to accused number 3, 4, and 5. The answer that we're getting, my lord, is that this witness will not be testifying about accused number 3, about accused number 4, and about accused number 5. But the challenge that we have, my lord, is his name is included in the statement that we were furnished. On the statement regarding the interview with the suspect, his name is also included there. So I'm not so sure whether the state intends to, because the state specifically indicated that this witness will only testify in respect of accused number 1 and 2. I'm not so sure whether the state is then saying that this witness, for purposes of this trial within the trial as it is happening now, will only concentrate on accused number 1 and 2. And again, within the same trial within the trial, this witness is going to be recalled to come and say something, if there is anything to be said, in respect of accused number 3, 4, and 5, my lord. That is the clarification that we want to know. And the basis of this clarification, my lord, it's simply that if this witness were to start to say something about accused number 3, 4, and I'm not pleading the case here of accused number 4 and 5 as well, my lord, but we are in the same boat here. But if this witness were to start, as he is being led by the state, to say something in relation to accused number 3, 4, and accused number 5, then we will go back to the initial argument that we raised at the beginning, my lord, that before a witness starts to testify against accused number 3, 4, and 5, we would want to know exactly with certainty as to what is it that the state intends to demonstrate when it leads the evidence relating to the warning statements. In other words, what is it that the state would ultimately want to argue as being the content of the statement that it wants to prove before court, my lord. That is going to enable us to prepare our defense and conduct our defense in line with what the state is going to argue ultimately as to why it actually wants to lead to this information or evidence, my lord. Thank you, my lord.
Yes, Mr. Baloyi.
As you could please, my lord, I have indeed intimated to my colleagues that this witness will be confined to the statements that were made by accused number 1 and 2. Hence, we've been going through the occurrence book entries, and those pertain only to accused 1 and 2. Insofar as the issue is concerned that has been raised by Advocate Mnisi, that this witness might have commissioned the warning statement of their clients. Well, firstly, his evidence is not going to touch on that. I've given them that assurance. But secondly, my understanding of their defense during the trial, within the trial, is that their clients did not make any statements. So the commissioning thereof, with the greatest of respect, I don't think is at issue. They're simply saying, they didn't make any statements. So it's then for the state then to show that indeed a statement was made. And we must keep in mind at this stage, my lord, that it's only about the voluntariness of the statement and not the contents thereof. So Advocate Sergeant Mokhani's evidence, should we reach that point about the contents, will only be relevant at that stage if the contents of those statements are disputed. But for present purposes, my lord, we're not going to canvass that.
So these are the statements of accused 3, 4, 5?
Yes.
Because the defense of accused number 3, 4, 5 is that their clients did not make any statements.
Indeed.
But in the same breath, they want to know what is the contents of the statements.
Yes.
Is that what?
Yes. Well,
it's an oxymoron.
It's a two-pronged.
You know what's an oxymoron?
Two-pronged attack on the warning statements, but we are of the view, my lord, that shouldn't really be an issue at this stage, given their defense.
Mr. Mnisi, what's your response? Because Mr. Baloyi says your defense.
Yes, madam.
Is that your clients 2,
Yes.
3, 4, 5 never made statements?
Yes, madam.
Never made statements.
Yes, madam.
Yeah.
That is so, my lord. However, that needs to be contextualized. When we say they did not make any statement, I'm not even so sure whether I'm positioned now to disclose what actually happened. But I think ultimately it will have to come to the court, my lord. When I said that it did not make any statement, it does not mean that there's something that is not contained in this document, my lord. There is something that is contained in this document which it does not bear knowledge of. So on the basis of what is contained in the statement, prima facie, there's a statement that was made, but our defense is it did not make that statement. That is what I meant by saying it did not make a statement, my lord. He bear no knowledge of what is contained in here.
Yeah,
and the
fine,
state
yeah,
insists, my lord, that they would want to prove the statement. And I don't think that the state would simply want to prove the statement or the document simply for the sake of it being a document. There is something that is contained in this document that the state would want to demonstrate and bring it to the attention of this
court. Is there any unlawfulness in that aspect? Because this court, if anything is unlawful,
yes, madam,
and doesn't comply with the Constitution, I won't allow it. But I don't know what you guys are talking about. I don't know. All I know is what the state is telling me, that they have a witness who's not going to traverse
Yes, my lord.
the evidence of number 3, 4,
Yes.
5. Is going to testify in respect of the evidence of 1 and 2.
Yes, my lord.
And then Mr. Baloi says, you, as far as he's concerned, your clients, you have told him, did not make any statements. But he is saying your clients made statements. That's it. So let that matter be resolved by the evidence. I told you about officers of court to tell this court one thing and the other thing. I mean, what should I do? He says your clients made statements. You say your clients didn't make statements. How will I know? I don't have them here. Let the evidence be led. If those statements are inadmissible, we'll see. If they are admissible, we'll see. I don't know. I can't prejudge the issue here now. Okay.
That is the reason why, my lord, I am standing and saying that in the document where the state alleges that our client made a statement, the name of this witness features. But the state then says, no, don't worry, this witness will not say anything about your client. So we don't know whether we need to cross-examine this witness or what.
Any witness who testifies here, you have a right to cross-examine him or her. Okay.
As it please the court.